I'll be back in 10 seconds.
Okay.
The court is back in session.
All right. Good afternoon, everyone, and welcome to the North Carolina Court of Appeals. We have our third case on the docket today, Erie Insurance versus Smith. We've established that the appellant would like to reserve 6 minutes in rebuttal, and that the appellees are going to divide their argument 15 minutes each. Are there any other matters before we proceed? I'd like to introduce the panel today. My name is John Tyson. We're joined by Judge Hunter Murphy and Judge Toby Hampson will be your panel for today. And if there's no further matters, we will hear from the appellant.
Mr. Dedman, you're muted.
Apologies for that. May it please the court, my name is Jim Dedman and I represent the appellant, Universal Underwriters Insurance Company, in this matter. This case arises from an April 2016 automobile accident and concerns the insurance coverage, if any, available to the estate of John Pinto. Universal appeals the January 15th, 2020 order of the trial court, which granted the motion for summary judgment of Erie Insurance, Mr. Pinto's insurer, and denying the motion for summary judgment of Universal, the insurer of Valley Auto World, the dealership where Mr. Pinto bought the vehicle prior to the accident in question. Universal believes that that order should be reversed because North Carolina General Statute 20-75.1, which governs conditional delivery of motor vehicles, did not apply to the transaction at issue, and thus there are no circumstances where Mr. Pinto could become an insured under the Universal policy. We also contend that even if Mr. Pinto did become insured under the Universal policy, he would only be entitled to the minimum financial limits under North Carolina law and not the full limits of the policy as found by the trial court. As a part of that, we argue that Mr. Pinto would not be entitled to any umbrella coverage under the policy. As the court is aware, this case has been before the Court of Appeals before. In an opinion from 2018, the court determined that a necessary party had not been joined. That party was joined since the issuance of that opinion, and the trial court did address those issues and found that there were no other insurance policies which were in play other than those issued by Erie Insurance and Universal in this matter. As a very brief revisiting of the facts of this case, the accident in question occurred only several hours after Mr. Pinto had purchased the 2013 Volkswagen that was involved in the accident. He purchased that vehicle from Valley Auto World, the dealership which is insured by Universal. The purchase price was $14,500, which included a $2,000 trade-in of a Saturn that he owned. While at the dealership and before executing any documents governing the transaction, Mr. Pinto applied for and was approved for $11,990 in financing, which left a $510 gap between the amount owed and the amount of financing. Generally,
if I can just ask a factual question that I've had a question about as I've gone and reviewed this case, and maybe I've missed it. Did the Saturn that was used for the trade-in value, was the title transferred on that Friday, or had he executed a power of attorney to allow the dealership to transfer that on that Friday? Was that part of the transaction completely done, or was there more work Mr. Pinto was going to need to do for that part? part of the transaction?
It was a Saturday, I believe.
Okay.
And as I understand it, I believe that Mr. Pinto was to return to the dealership to provide the title for the Saturday.
So that consideration had not been completed yet at the point of when he left the dealership with the vehicle, correct?
That's my understanding. Yes, sir.
Thank you.
And the testimony from the two managers of the dealership establishes that from the dealership's perspective, the transaction had been finalized. Mr. Pinto had, quote unquote, obtained financing to facilitate the transaction. Both of the managers testified that they felt that the financing was full and complete and that it would not have affected the nature of the transaction going forward. In fact, even though they contemplated the possibility of seeking additional financing to cover that $510 gap, they did testify that they did not believe that anything subsequent to the arrangement on Saturday, April 30th, would have affected the validity or status of the finance.
Wouldn't that testimony, though, be parole evidence that in this case that wouldn't be admissible for consideration for summary judgment purposes?
Well, I think that certainly was not an objection on those grounds to the consideration of that testimony during the summary judgment proceeding. I think all of the parties have relied on that testimony and the interpretation of the managers of the transaction at issue. Some of that testimony does relate to what occurred before the documents were executed. But some of it also concerns what was to happen after the fact and how those agreements were to be administered following Saturday, April 30th. But I don't believe there was an objection to that testimony, and all of the parties, I think, are relying on that testimony as a part of this matter.
I have one question before we go ahead. Can you solve for me the $510 gap? Was that something we applied for and approved by the finance company, or were they going to waive that? I do remember this case, I think from last time it was here. And I know that was a question of whether or not the transaction was complete. And I think Mr. Pinto had to return with the title to the Saturn, if I'm not mistaken. Is that said?
Yes, sir. And that did come up at the oral argument last time. With respect to the other question, Mr. Pinto died several hours after purchasing the vehicle, and the dealership was unaware of that. And so on Monday, following the Saturday, the dealership did apply for additional financing for the gap of the 510, and VW Credit did subsequently approve that. Of course, no one knew what had happened. The testimony is that regardless of what had happened, the gap of the $510 would not have killed the deal. They would have written off that 510 in order to ensure that the deal was completed.
But was the title to the Saturn ever delivered?
I do not believe it was, not to the dealership. The plan, as I understand the record, was that Mr. Pinto was to return to the dealership with that title, and because of what happened, he was unable to do so.
So we don't know. I mean, did a family member, executor, no one ever actually delivered that title?
Ultimately, with respect to the Saturn, I do not know. There is some evidence in the record that there were some challenges in setting up the estate of Mr. Pinto, who was estranged from his relatives. And I'm not sure that anything was done on his end with respect to the title for the Saturn, at least during that period shortly after the accident occurred. I don't believe the estate was set up for Mr. Pinto until after this litigation was instituted by the Smiths the first time around. So,
if I'm correct, if we're thinking about the state law principles, no estate was set up, No personal representative was acting when these documents were submitted on Monday. Nobody ever acknowledged them or took on the debt. So the debt was actually never incurred, was it?
The debt of
Mr. Pinto
for the Saturn.
for the purchase of the new used vehicle. The debt was never actually incurred.
Well, certainly nothing happened after the Saturday because of his death. I do know that after the fact, the financing did go through, and Valley Auto World did receive the money, and I believe paid off the debt. But Mr. Pinto did not himself do anything with respect to any obligations arising from these transactions, and neither did the estate, as far as I'm aware.
But no obligations were ever actually created. So there was never a completion of the purchase. Even if financing went through, people moved paperwork around. You know, a dead person can't act, and no one can act on their behalf. And you don't have a state coming in later saying, yeah, we're going to take on this debt. So was it ever a completed transaction? Well, I understand there's paperwork moving around, but in terms of there actually being a transaction between Mr. Pinto and the dealership or the company holding title to the vehicle, there never really was a transaction, was there?
Well, there was paperwork executed at the dealership. There was, the financing was approved. Mr. Pinto signed several documents while at the dealership, and he did take possession of the vehicle and drive away. I think that there's several circumstances related to the transaction which are relevant here and which apply to the analysis. And of course, one thing that we talked about in the briefs, in which the court addressed in the prior opinion, is that the dealership did not have title to the VW at the time it intended to sell it. And so there definitely were some issues left to be addressed. Ultimately, VW Credit did transfer title to Valley Auto World, and I believe that there was a title that was ultimately transferred to Mr. Pinto in May, although by that time he had been deceased for some time.
Well, on that issue of ownership, if I'm not mistaken, it looks like the only place that's brought up in your opening brief looks like page 17, footnote 4. Is there another place in your brief that you're arguing about the ownership issue? And if not, is raising it in a footnote in this way enough to say that you're advancing that argument on appeal and it hadn't been abandoned?
Well, I think that we have raised that issue below, and we have raised it here. I think that we have raised it in with respect to the fact that the analysis as to whether or not this sale was a conditional sale and delivery under section 20-75.1 is premised on the notion that one has the ability to sell something. And we did cite, I believe, some authority to the effect that you can't sell something that you don't own. And so this particular statute, we certainly have dedicated a considerable amount of the brief to the argument that the statute does not apply. And I think we do reference in the briefs the argument that because of the curiosity of the fact that the dealership did not own the vehicle at the time that it was purportedly selling it, that therefore a statute governing sales and delivery cannot apply.
Well, if we were dealing with real property, equity would step in and immediately vest title in the purchaser of the dealership upon receiving that title. Is there not a similar concept when it comes to ownership of personal property?
Well, there's certainly not any guidance which explains what would happen in this situation with respect to the application of the conditional delivery of the vehicle. 20.75.1 does not our reading of that suggests that in order to sell something, you must own it. And one of the reasons why the court vacated the prior judgment and instructed parties to bring in VW credit was to address some of these issues. We had thought that there might be some type of document which was produced, which would shed a little bit of light on the ability of the dealership to sell a vehicle that was titled in the name of VW credit, but that was not discovered in the case. But I don't know that I would say that the argument that VW or Valley Auto World did not own the vehicle, thereby rendering the statute inapplicable, is our foremost argument.
Well, let me ask one more question, just real quick on this owner and dealer issue, and then I'll sit back for a little bit. But when I'm looking at 20-75.1, the statute is talking about dealers. It's not talking about owners. And I think if the legislature had intended it to only apply when somebody's entering a deal with an owner, they would have said so, because it's clear here it's about dealers. And given this is kind of, it's not the most common thing, but it's not unheard of either. I don't see where the owner issue comes in to whether 20-75.1 applies or doesn't apply.
Well, we have several arguments why it doesn't apply, and that is one of them. The other is that the vehicle was not conditionally delivered, because the condition that's contemplated by the statute had already occurred prior to the sale and delivery of the vehicle. I do think that the statute is designed to facilitate deliveries and sales of vehicles, though. And it does use the word sale, and I think that in order for there to be a sale, someone who owns something must sell it. But I think that our primary argument there is that Mr. Pinto had obtained financing prior to the delivery or sale of the vehicle, thereby rendering the statute inapplicable in this case.
What is the response to the idea that the dealership is serving basically as the agent to conduct the sale on behalf of the title holder?
Well, there's nothing in the statute which contemplates that, and there's nothing in the record which contemplates that issue. I mean, that is one of the issues why why VW Credit was brought into the case, and that particular arrangement is not in the record. And so I think that if that arrangement, whether it be contractual or whatnot, was in the record, that might make this an easier issue to address. But as it stands in the record, there is not evidence to suggest that Valley Auto World did have the ability to sell this vehicle it didn't own. It may very well have, but
I may be relying on memory, but my memory was that the VW that Mr. Pinto bought was a rental return vehicle, and it had been leased, or a lease return vehicle. It had been leased by VW Credit, that Valley Auto was authorized as a dealer to receive returns of leased vehicles and to sell them on behalf of VW. Is that not correct?
That's correct, Your Honor. Yes, sir.
And so going to the fact of a dealer versus an owner, generally when you trade in a car, from my experience, you trade in your car, you deliver it, the dealer never really takes ownership of the vehicle, except they take an assignment of the title, and when they sell that vehicle, they assign it to the subsequent purchaser. Is that not the way it's generally done?
I think that's correct, Your Honor, and we did address that previously. The vehicle was returned as a leased vehicle by a prior owner named Cheryl Copes. I believe it sat on the lot for several weeks before Mr. Pinto expressed interest in it. I think what is unusual about this particular case is that usually, as the managers testified, it was unusual that they were selling this vehicle that the dealership itself did not have legal title to. The Smiths did raise some issues in this case and the prior case about the manner in which that transaction was handled. But I think you've accurately described the general arrangement.
Isn't there, let's say you buy a dealer buys a vehicle from an auction, doesn't the paperwork always kind of follow? I mean, it's kind of a catch up. Doesn't the paperwork kind of always catch up with the transaction later on?
I think that was, yes, and I think that was probably the intent here on some level. I think that if Mr. Pinto had lived, ultimately he would have obtained the title from Valley Auto World, who would have obtained it from VW Credit. And
hopefully that's what happened, right? The title was actually issued to him after his death.
Yes, and so I think that probably would have been something that no one would have noticed or been concerned about, but for the accident which happened. And so I think that still happened despite the accident. But I think that the issues of the ownership of the vehicle and the circumstances surrounding the transaction at issue really become irrelevant if the court determines that the statute does apply. Because all that the statute does at the end of the day is make the vehicle at issue a covered or owned auto under the universal policy. And then you just treat that vehicle as a covered or owned auto just as any other. And so once you reach that stage of the case, all of the circumstances surrounding the curiosities of the sale and delivery of the vehicle are no longer relevant to the coverage analysis. And I think that really is one of the key points in this case. The conditional delivery statute doesn't speak to who becomes an insured. It doesn't speak to what policy limits are. It doesn't speak to what claims are covered. All of that is a part of the coverage analysis which takes place once you decide that the vehicle is a covered or owned auto. And so we think that although the conditional delivery agreement statute does not make Mr. Pinto an insured, Mr. Pinto probably would be an insured under the universal policy if the vehicle was required to be covered by that statute, because persons who are operating covered autos with permission are insured as a matter of law.
And on that point, Mr. Dedman, can we start moving towards the arguments on which limits apply and sort of the primary excess coverage issues, which I think is sort of related. And then, as I understand your argument, it's that probably the most applicable provision of this would be probably the auto hazard component of the insurance policy, which would provide minimum limits. I think on one hand, it's your argument that doesn't apply, or I'm sorry, that should, if anything should apply, that should apply here to provide minimum limits, primarily because this vehicle was still within the care, custody, and control of the dealer. And so that's where it falls under the auto hazard. Am I understanding that connection?
Yes, sir. Yes, sir. I think that there's actually two potential coverage parts which are in play, and one is the auto hazard, which is a component of the garage policy. The other is the basic auto component. But both of those coverage parts say that if you become an insured as a matter of law, as Mr. Pinto did, then you are only entitled to the minimum limits. That makes sense because that would be the same result as in a test drive. Because if Mr. Pinto had showed up at the dealership and had said, let me do a test drive of this vehicle, and the same accident had happened, then I think it would be clear that as a permissive user of a covered or owned auto, he would have been entitled to the minimum limits. And so there's nothing in this conditional delivery statute which suggests that a person under this particularly unique situation would be entitled to a windfall of coverage in this case, unlike a test drive. And I think that insureds by operation of law are not entitled to umbrella coverage under the policy. There's two umbrella coverage parts. There's a personal umbrella and there's a commercial umbrella. Both of those are limited to either named insureds or specific categories of people that no one contends Mr. Pinto is a part of. And so...
I'm sorry, Mr. Bennett. Stepping back to the general liability policy, can you give me a brief example of when the full policy limits would apply? What situation does that apply? Would those limits apply? I guess the $500,000.
Well, I think you would have to have a named insured. If you look at the who is an insured section of the policy, you would have, based on both coverage parts. I mean, it would be a named insured or certain categories of persons who are specifically identified in the who is insured section. But both who is an insured sections specifically carve out persons as or persons who are covered as a matter of law or who become insured as a matter of law as only receiving the minimum limits. And so it might be that if a employee of the dealership had the same accident, you would have a different result. But because this is a person who is not a named insured or not an additional insured, only someone who happened to become an insured by operation of law, that category of insured is limited to the minimum limits. And I do see that my time is out if I'm going to reserve 6 minutes, and I don't have 6 minutes left. So I think I'll reserve the balance of my time unless the court has any other questions for me.
Are there any more questions of Mr. Dedman this time? If not, we will reserve the balance of this time for rebuttal. Okay. Thank you, sir.
Thank you.
Okay, we'll hear from the appellee. I understand you're going to divide your time. Which one of you folks are going to argue first?
I am, Your Honor.
Okay. You may proceed.
All right. May it please the court. My name is Tom Van Camp. I represent Edward Smith and his son Archie in this matter. I'm going to try to focus on four distinct points that really address the Universal's four primary arguments. The first one being the representation in their brief on page 9 in footnote 2 that the precedents established by this court in the past is not instructive. We disagree and believe that especially Judge Tyson's decision in Universal versus Baker is directly on point. Secondly, this concept that the Universal is purporting to argue that the policy limits somehow trump the statute and what is defined as statutory coverage, and that you look at the policy to determine who is an insured, and how that analysis is fraught with problems, not just this case, but any other case. Third, this concept that the policy limits are $30,000, the underlying policy limits, because this is an auto hazard or a garage operation. By definition, neither of those apply in this case, which takes you back to the $500,000 of underlying coverage and then to the umbrella coverage. And lastly, fourth, this idea that Mr. Pinto's financing was approved and therefore the statute does not apply in this particular case, and that it was approved on April 30th, 2016, rather than May 2nd, 2016, after the accident occurred. As to the first point, it's interesting. We have argued this case before this court, before we've argued it in front of multiple trial judges, and you go back and you start reading it, and I went back and reread Judge Tyson's decision in Universal versus Baker, which is a 2003 unpublished case, but is the only case in which the exact fact pattern occurred. Specifically, Mr. Thompson went to Nissan, the Kinston Nissan dealership in September of 2000, traded in a car for $1,000. He bought a 1995 Mitsubishi and left under a conditional sale agreement, which is similar to a conditional delivery agreement. His financing had not been approved and title had not transferred. Both things are similar in this case. Mr. Thompson leaves the dealership with the car, with no title, financing with Wachovia still up in the air, and not finalized as the statute requires, and he hits Mr. Thomas. Mr. Thomas then sues Mr. Thompson, and Universal, ironically, is the insurance company for the dealership, Kinston Nissan. Universal files a DEC-J, or declaratory judgment action, to determine whether this statute applied and whether they provided coverage, or whether Mr. Thompson's carrier, Wilshire, provided coverage. The trial court found that Mr. Thompson wasn't insured by virtue of the statute, not the policy. And that decision was affirmed by this court. Now, there are some critical points in that case. It involves the exact same scenario we have here. And the only thing that the Court of Appeals, this court, looked at and examined was the policy limits. And the trial court found that the policy limits were $30,000 based on the coverage in the policy, not on the Financial Responsibility Act and minimum limits in 20-279.21B2. So they found that Mr. Thompson wasn't insured. There was no analysis. There was no argument. There was no discussion about Universal's policy and whether you could uninsure Mr. Thompson or read that policy to take away what the statute gave, which is what Judge Tyson referred to as, quote, statutory coverage, end quote. And that's what we have here, statutory coverage. If you say somebody is covered by a vehicle or a vehicle's covered and the only intended driver of that vehicle is a customer who takes it conditionally based on what this statute permits a dealer to do, you cannot then turn around and say the person that you know is going to be driving the car somehow isn't insured unless the policy says they're insured. And that is what that case said. And if you take the parties in that case and you take Valley Auto World and simply substitute them for Kinston Nissan, and you take Mr. Pinto and you substitute him for Mr. Thompson, and you take Mr. Smith and you substitute him for Mr. Thomas, and you take VW Credit and substitute for Wachovia, and you take Erie and substitute it for Wilshire, you have the identical fact pattern with none of this complicated discussions regarding these things.
Mr. Van Camp.
Yes, sir.
The fact that some of those things aren't discussed and they're being argued now, and that in the past, even though there's an overlapping panel member, it was an unpublished case. And just because it's on all fours isn't reason to find it persuasive alone. If so, that would be the case with any unpublished case.
I think it's persuasive, it's not precedent.
Yes. So persuade me that our court got it right there, given the arguments that Universal is making now, and why we should follow Baker as persuasive authority and adopt it here.
And so that kind of takes me to the second point. I will say the Hester case and the Hicks case talk about this transfer of insurance. And I think Judge Murphy, if you think about the legislative history of this statute, these spot deliveries or conditional deliveries were unlawful in many states. And North Carolina dealers pressed to want to be able to do this, because on Saturday you can't do the title work, and on Saturday a bank is not going to get back to you necessarily with final financing. So if you look at that legislative history, which is contained in our brief, what ends up happening is you can see that there was a trade-off. we're going to let you do this, but you have got to cover that car until final financing is approved. Final financing. It's written 3 times in the statute, and title transfers. So to allow a dealer to take the financial, and this is not a test drive. The dealership made money on this deal, or would make money on these types of deals. There is an incentive there. So what the legislature says, we're going to let you do this, but if you do it, you have to have this vehicle covered. Now, this concept that the vehicle can be covered, but the driver is not, no purchaser will ever be named in a dealer's policy as a named insured. They don't know who the individual is. It's different customers. They come, they go. So to be able to point to that and say, well, you're not a named insured. Aha, you have just rendered the statute and what the legislature intended meaningless, because cars don't drive themselves. People drive cars, and the only person that we can contemplate driving this car is Mr. Pinna. They gave him the car.
And so, like, assuming for a moment that indeed the conditional delivery statute applies, Mr. Pinto wasn't insured. That still leaves the questions of which limits are applicable, and I guess whether the umbrella policy applies, which insurance is primary, secondary. But address for me this for a moment, the concept that this is not an auto hazard under the policy, because your argument is that Valley Auto World was not a title owner of the car, but yet you also argue that Valley Auto World did not retain any care, custody, or control over the vehicle. Isn't that at cross purposes with your argument that this is a conditional delivery? Because it seems to me conditional delivery is kind of premised on the concept that Valley Auto World can claw back the car should the financing or any other, frankly, condition not be met.
Ultimately, I agree with that. But what the auto hazard in that entire policy, Part 500, talks about is at the time of the occurrence, at the time of the accident, then Valley Auto World has to have care, custody, or control of the vehicle. They had none of that. They would never have seen that vehicle again, but for this accident or but for this case, and the car was totaled, by the way. So you don't look at what could happen in the future. You have to freeze this in time and say they didn't own it, and that's just a reality. The statute doesn't speak to ownership, doesn't require ownership, and they didn't have custody, care, or control over it because Mr. Pinto did. Otherwise, you'd have a respondeat superior argument that Valley Auto World's liable for Mr. Pinto's negligence, and we'd have a much easier run at getting the policy. So I don't think that the auto hazard applies, and there's an additional requirements beyond the care, custody, and control. It also must be used in their garage business, used principally or for occasional use for business purposes. I mean, this situation it's contemplated in the statute, and to Judge Murphy's point about persuade me that was a good decision in Baker. If you take the Universal's argument to its logical conclusion that there's only $30,000 of coverage, then we have just cheated Mr. Smith, who lives in a wheelchair for the rest of his life, out of $70,000 of coverage. Because Erie has 100. Mr. Pinto had 100, but the way the statute works, it's either one or the other. So once you say the statute is applicable and it's only $30,000 in coverage, you just did precisely what the Proctor decision says you should never do. And that is, when there is a statute that extends coverage to an innocent victim, it must be read liberally to afford the most coverage possible. That's cited on page 25 of our brief. So at the end of the day, these arguments made by Universal, the more you go around, they hit a wall every time with a very absurd, illogical decision. And, or result. And again, to say that you look at the statutory, the canons of construction and the principles of law say that the statute always governs over a policy. And that if there's a policy provision that is contrary to the statute, it's void. And so from our perspective, the only inquiry in the Baker case is, what are the policy limits? And I agree with Mr. Dedman that in the declaration pages, there are 500,000 and $1 million, and 10 million rather. The umbrella is a liability policy. It is defined as a liability policy. The statute says any liability policies that cover the dealership cover that vehicle. You can't undo that by saying, well, Mr. Pinto, we forgot to name you as an insured. You're never going to be named as an insured policy. You've gutted the purpose of the statute. This is a perfect storm. This hasn't happened probably since 2000, when the Baker accident occurred, where you actually have, before financing is finalized and before title is transferred, an accident, especially of this magnitude. So, but that's what this statute is designed to protect. So the $30,000 limits, I don't think apply. And if they did, I think you add those to the 10 million, and it's sort of a moot point.
Hey, are there any cases, and maybe you pointed to me, and it's been a long day and I'm forgetting it, but are there any cases that have applied that presumption to help the innocent party to an umbrella policy versus just the applicable auto policy?
I haven't looked at that issue specifically, but if you look at the plain language of the statute, it says liability coverage applies, the dealer's liability coverage. So the next phase of the analysis is umbrella policies, or are they liability policies? And we have presented multiple cases and legal sources that have said that's a liability policy. So at that point, you're at a fork in the road. You can either read the statute narrowly and deny coverage, which would be contrary to the canons of construction, the Proctor and other cases, or you can read it liberally to provide coverage to the, quote, innocent victim, end quote, which is how they're defined. And so that is the situation here. You would have to go against lots of legal principles to squeeze this square peg into this round hole that Universal is trying to accomplish. And I see my time is up. I don't want to.
I've got a question for you.
Yes.
We'll extend for a moment for questions from the panel. Again, I'm going back on facts, just memory too. My understanding was that Mr. Pinto had notified his insurance carrier and his tags had been transferred from the Saturn to the VW. Is that correct?
I believe he had changed. He was with Erie, and Erie's policy was going to cancel at midnight that night after the accident occurred, and he was going to be with USAA at that point. But yes, I think you're correct. The financing wasn't finalized, and the title hadn't transferred. So by law, by statute, even though Erie and/or USAA were in the wings, their coverage wouldn't take effect until those two events occurred per the statute.
So the Erie coverage did not travel with him on the vehicle that he was driving?
I would argue that as an insured, it would be excess, but the statute kind of has an either or point there, and it's either one or the other while we're in this gap period of time. Erie argues that they're not responsible. Again, leads to a bad result, even worse than if this wasn't a conditional delivery for Mr. Smith and his son.
What is the status of USAA? I don't even see them in the case at all. Is that correct?
Their policy didn't take effect until midnight on the 30th, and the accident occurred, I think, 6 or 7 o'clock on the 30th. So we dismissed them. Everybody agreed they had no dog in the fight.
But Erie is named, and their coverage on Mr. Pinto was still in force when the accident occurred. Is that correct?
That's correct.
Okay. But you're saying the statute says you either go against the drivers or you go against the dealers coverage?
That's, if you look at Chief Judge McGee's opinion in the Hester case, as well as this court's opinion in the Hicks case, both cited in our brief, they carve out a very specific transition of coverage where it's on the dealer's policy for the period of time until financing is final and the transfer of title. And neither of those occurred. So Erie's position that they weren't up to bat yet is consistent with the statute. And you know, I'll say this. In the Baker case, the policy limits were just 30-60. I mean, in this case, they could have been, you know, less. I mean, this is a perfect storm, a horrible accident, horrible injuries, and a lot of coverage. I guess that's why we're all here, probably.
Okay, thank you.
Thank you, Your Honor.
All right, we'll hear now.
May it please the court. Good afternoon. My name is Lee Thomas. I'm here on behalf of Erie Insurance Exchange, the plaintiff and appellee in this matter.
Thank you, Mr. Thomas. Good afternoon. Welcome to the court.
Thank you, sir.
And maybe we can start with that first question.
And of course, and if I understood Your Honor correctly, the question was the Erie policy still in effect at the time of the accident?
Not only that, but if the plate from the Saturn, if he had Erie Insurance on the Saturn and the plate from the Saturn, he traded the Saturn in and bought the VW and put his plate he left with, wouldn't that coverage as it relates to a third party, wouldn't that go with him or not?
Well, Your Honor, I think in my mind, the way that I'm framing your question, and it really goes back to the fact that this is a conditional delivery and sale. Because of the documents that Mr. Pinto signed at the dealership stating that this is a conditional delivery agreement, I think then we have to look at the mandatory language of the statute to say that the dealer's policy shall apply. I think that transfer of the plates is particularly determinative of whether or not the Erie policy would apply to that versus it essentially migrates from the Saturn to the VW. I think because of
was there any evidence that the dealership, Mr. Pinto, had put y'all on notice? Did he get a binder? Did he call his agent to get a transfer of coverage? That was a weekend.
I can tell the court that it's not in the record, but I can also tell the court that it's my understanding that Mr. Pinto had called either his agent or Erie directly, possibly while at the dealership or very shortly thereafter, perhaps from his cell phone in the car, to cancel the policy. And I think Mr. Van Camp is correct. This USAA policy that he had decided to purchase to take effect, I believe was to take effect beginning May the 1st, which was, by my math, that would have been Monday following this Saturday accident. But we have not contested, and again, it's not in the record, we don't contest or deny that the Erie policy was in effect at the time of the accident, because I think under North Carolina law and the policy language, you cannot bind or change coverage by telephone or voicemail. So we haven't contested that.
Do I understand your argument then to track what Mr. Van Camp said, that the Hester opinions and the precedent say, and the statute says, it's either dealer coverage or driver coverage, right?
That's exactly correct, Your Honor. And that is the primary argument that we put forth in the trial court, and we've raised it in our brief here as well, is that it really is either or. And we've used the term trigger in contrast with coverage, but the trigger really here, based on the fact that they've signed the conditional delivery agreement, then you have to look at the mandatory language of the statute. And the first, the sentence in the statute does say, liability, collision, and comprehensive insurance on a vehicle sold and delivered, conditioned on the purchaser obtaining financing, etc., shall be covered by the dealer's insurance policy until two events occur. the financing is finally approved, and the execution of the certificate of origin or title. The very next sentence talks about upon final approval and execution, and upon the purchaser having already obtained some insurance, perhaps on an existing vehicle that he will transfer, the vehicle shall be covered by the purchaser's insurance policy. So it really is the mechanics of the statute really are you look at a triggering event, or two events really, the financing and the certificate of title. And again, there's no, we have argued, and the trial court correctly found that the financing wasn't finally approved. If it had been, the dealership would not have submitted a second application on Monday after the accident seeking that additional $510. And the certificate of title, we disagree with that argument that you can't sell something you don't own, because I think, as Judge Murphy was talking about, the statute talks about dealer. But I will say that the certificate of title in the chain, it had to go from VW Credit to Valley Auto World. And that is in the record, I believe, at page, apologize, I just made a note of that while there were some discussions. The reassignment of titles, I believe, are in the record at page 730 and 731. Now, I will say the 731, there's some discrepancies about whether or not that was even lawful. But the reassignment from VW Credit to Valley Auto World is the first step. And then the payoff had to occur. The testimony, I believe, revealed that the dealership did not become the title owner until May the 9th, which is over a week after the accident. And then the DMV records that are in the record, I believe, I apologize, I just had the page number, I could find it. The transfer to Mr. Pinto officially with DMV on their title docs did not occur until May the 23rd. So well over 3 weeks after this accident. So because neither of those triggering events had occurred, the Erie policy does not even come into play. You look at the dealer's policy here, which is the universal policy.
Mr. Thomas, so I actually have an appellate jurisdiction questions on this issue that you raised on behalf of Erie. That is the trial court made an affirmative ruling, if correct me if I'm wrong, that Erie provides coverage, albeit secondary or excess coverage behind Universal in the case. Is that correct?
That's correct, Your Honor.
And you contend that was error.
That's correct.
And it would require us to, agreeing with your argument, would require us in part to reverse that portion of the trial court's order. Is that correct?
That's correct, Your Honor. We've asked for the court to reverse essentially the first paragraph of the denial of the first paragraph of our motion for summary judgment.
So my concern is this: you articulated that we have jurisdiction based on this being an alternative basis for the trial court's judgment. My concern is that this doesn't seem like an alternative basis for the trial court's judgment. This seems like an adverse ruling that Erie was required to file a notice of appeal from, right? This is an instance where you've got a trial court, there was negligence, but there was contributory negligence, right? So negligence becomes an alternative basis for summary judgment. Here, this is not an alternative basis for upholding summary judgment. This would require reversal of the rule. So I'm struggling with how we even have jurisdiction to address this question. Can you address that, please?
Sure, Judge Hanson. And I do understand the court's question or concern, as it were. I think under the appellate rule, I believe it's 28F, which we've raised, that you can bring an alternative basis. I think essentially because the court ruled that it is a conditional delivery, and you do have the universal policy, which is in effect and provides the $10,500,000, and then you would look to Erie. I think our argument, Your Honor, is that the court essentially said that it is an either or. We think it should be. They said the $10,500,000 is on the table. You may not even get to Erie's policy. So as it's applied, Erie may not, you have coverage, but you may not get to it. But I think to say that, you can't raise this on appeal when it certainly was raised in the motion. We asked the court as an alternative ruling. I think the court certainly can correct the error without filing the notice of appeal. And I think that's why the rule exists, because I think I would just refer to the brief, Your Honor. Frankly, I think the rule, the plain language of the rule says that we can raise that without taking an appeal. And I think by saying that there was excess, because in our complaint, we did ask the court to say there's no coverage. The first count of the complaint says trial court find no coverage. The court essentially denied that or overruled it. So then we've raised it. I don't think we needed to raise the issue on appeal.
Let me ask you just a little different way, the way I'm conceptualizing it, and see if maybe this can spur maybe a little bit more response. My interpretation of 28C is, let's assume the appellant loses and we affirm the trial court's ruling. Then your argument has to become moot for 28C to come into play. And your argument would become moot if we just affirm the ruling against the appellant, correct?
I'm not sure that I follow that, Judge Murphy. I apologize.
For it to be an alternative basis to support the order, if appellant loses and we just simply affirm, then you wouldn't have any argument that needed to be heard. And since your argument would still need to be heard, then it's not an alternative basis to support the judgment. And I think further part of the problem is too, that if we allowed it to go this way, then that denied the Smiths of any ability to partake in the adversarial process to reply or to respond to your argument. Because they filed their brief, then you filed your brief. They don't have an opportunity to come back and argue against what's being raised in Erie's brief on this issue. So I think that's how it's supposed to work, is the reason that you needed to do a notice of appeal would allow the Smiths to respond, because you'd be adversaries in that situation, correct?
I do understand that proposition, Judge Murphy, but I would say I think that in the prior decision of this court, based on quite a long precedent, I don't think that Mr. Van Kam's clients had standing under the statute or the Erie policy to contest that coverage. So, allowing them to address that on appeal, I understand, of course, they'd have a right to be heard, but I don't believe that I think the standing analysis really sort of takes precedence over any concern whether they haven't been able to respond to it. I think in their brief, especially, they conceded that the coverage isn't triggered. So, I think that if the court had said there is no coverage under the Erie policy, and you've got the universal policy here, that would be an alternative basis to find that coverage is afforded the $10,500,000.
What if we agree that the umbrella is not at risk and they're left just with the minimum coverage plus your policy as a secondary carrier, secondary liability? Where does that leave us?
Judge Tyson, there was a bit of a cutout. Did I understand the court to say if the umbrella does not, if the court were to find the umbrella does not apply?
Yes.
And then I didn't hear the very last portion of that. I apologize.
Where does that leave? Where does that leave the Smiths then? Does the statute under Hester, does Hester say it's either the minimum limits of the dealer or Erie? And where would that leave them? Would they be limited to the 100,000?
Well, again, Judge, I think that the umbrella policy aside, I think that those exclusions raised by Universal in their brief and Mr. Van Kamp touched on don't apply to limit that to limit the 500,000 from Universal. But I still think the plain language of the statute has to be either or. I don't think the analysis can include or should include a discussion of primary or excess of the liability with Universal and Erie's. And I think that's, had this been a test drive, I think we'd be in a totally different situation and they hadn't signed that conditional delivery agreement. I think in a test drive situation, you definitely would have to address situations of, okay, if he's a permissive user under the dealer's policy, plus he's got the Erie coverage, what comes into play, who's primary, who's excess. I really think that triggering event and the language in the statute that says upon those two events, purchaser's policy applies. So I don't think the statute really permits that analysis.
Well, we've had a lot of delays in the issuance of titles because of COVID, DMV. It's taken months for titles to issue. Where does that put us as it relates to those? That's not the fault of the dealer. It's not the fault of the purchaser. It's not the fault of itself. It's just the fact that DMV is not processing the titles timely for months.
Sure. If I may, Judge Tyson, I think I want to be clear to distinguish between the execution by the dealer or owner, as it were, just sort of speaking in the abstract, versus the DMV issuing a new title that is printed with the new purchaser's name. I think the statute speaks to the execution of the reassignment by the current owner or dealer. So I don't think the delay concern that the court is setting forth, I don't think, I think the statute talks about the signing of it, not the reissuance by the DMV of a new paperwork that shows who's the owner.
Back to the weekend again, where that seems to be the issue. There's no way that thing could be processed until the following Monday. Is that correct? That's when it was processed.
Your Honor, I think if there was not the issue of the payoff of the VW Beetle, and there had been a notary public or someone in the office to lawfully execute and notarize that reassignment of title, I think you could have done it.
Okay. All right.
But, and again, I think that's the distinction between signing it versus DMV processing it and issuing a new title.
I've made you go over your time. I'd like to give you just a moment to summarize.
Thank you, Your Honor. And again, I'll just direct the court respectfully to the brief. We've argued, again, the policy is not triggered. Universal's policy is on the hook. Even if you trigger the Erie policy, the regular use exclusion does apply. This is not a covered auto. And even if it was newly acquired, the coverage would not apply until he became the owner of the vehicle, which was, again, not until May the 23rd, well after the accident. It's not a temporary substitute. Again, this was a transaction in which, like Mr. Van Camp said, the dealership was never going to look back. This car was out the door. Mr. Pinto had it. It's not a temporary substitute. The Saturn was not out of its normal use because of any of those delineated possibilities, breakdown, destruction, loss. There's a few others. This was a traded vehicle that he never intended to get back. It was not a temporary substitute. And therefore, we would respectfully ask the court to find that there's no coverage under this exclusion.
Thank you. Any questions from the board, any of counsel?
No.
All right. Okay, I think I have now rebuttal. Is that correct?
Yes, Your Honor. We would like to respond to a number of points made by Mr. Van Camp, and I think it's important from the outset to note that this statute, the conditional delivery of motor vehicles statute, talks about the coverage of vehicles, not making a person an insured. There's nothing in that statute which says who becomes an insured or why. And Mr. Van Camp seems to believe that if the statute doesn't make someone an insured, then no one can ever become an insured. But that's not what we argued at the beginning of the argument today. We have acknowledged that if the statute does apply, then Mr. Pinto becomes an insured by operation of law. And that's the way it's supposed to work. And quite frankly, that's what the trial court said in this case. If you look at page 3 of the trial court's order, the last full paragraph, it says, in light of the finding that Pinto was operating a covered vehicle with permission, he became an insured under the terms of the dealer's policy. So the trial court recognized that it was not the conditional delivery statute that made anyone an insured. It was the operation of the permissive use of a covered auto. And I think that's very important to recognize. If it's true that anybody who is driving the vehicle is automatically an insured, then that would mean that if Mr. Pinto pulled to the side of the road to take a break and someone stole the vehicle from him, then that thief would be an insured. And that can't be the result under the analysis of the statute or the policy. I think it's also to point out, it's also important to point out that the Baker case that has been referenced, I don't think that the Baker case is controlling here. First off, because there was not the type of exhaustive discussion that we are having here about how the conditional delivery statute applied or the nature of the insurance policy in question. What happened is that the trial court had found that because of that statute, the dealership or the driver had coverage of $30,000 by virtue of the dealership's policy. But there's no discussion of what the dealership's policy said. And I think it's an overreading to say that that somehow dictates the result in this case, where there is a much more involved discussion about what the policies actually say. And then lastly, I think the critical point to identify here is that the Smiths have focused on the auto hazard and garage portion of the policy, but they've not dedicated any discussion to the basic auto coverage part, which is part 830 of the policy. As we acknowledged in our brief, there are two potentially applicable coverage parts of this policy: the garage and auto hazard, which are the same coverage part, and then the basic auto coverage part, which is an entirely separate provision of the policy. And so does this vehicle neatly fit into the universal policy? Maybe not perfectly, but the obvious result and intent of this statute is to treat this vehicle as a covered or owned auto under the policy. And so once you do that, then the coverage analysis under the policy begins. It doesn't end. And then the last thing I'll say is that I don't think that I don't think that there can be an argument about extending coverage to the victim of the accident, because as we said on the first time, on the first appeal, the accident victim doesn't have standing here. So the focus is on the coverage available to Mr. Pinto. And I see my time is up.
Any other questions of counsel? Okay, hearing none, we thank counsel for their arguments. We thank them for the briefs, and we will consider the case submitted. And we appreciate the good arguments and the good briefs.
Thank you.
Ms. Clerk, adjourn court, please.
Yes, Your Honor. This session of the North Carolina Court of Appeals is now adjourned.
Okay.